in your eastern part of nation, right? If you are going to search for who says Koi language, or who are proactively using it, now you can make a sense that because Odisha is where is Odisha lying? It's lying in southeastern part of India. That means any tribe which belongs to Arunachal Pradesh, Assam, Manipur, Tripura, etc., are not going to use this particular language. And hence, if in prelims you get a question about Kui tribe, you can make sense that yeah, it's the tribes which belongs to Arunachal and others are definitely not going to employ it, right? You don't have to remember the tribes of Odisha for this particular language. Rather, you need to only be aware about tribes and the general composition of them in various parts of nation, right? Then there is Schedule 8. We know what it does. So official language of country, and then 22 languages in the particular aforementioned schedule. 14 languages were originally there, and then we had 8 languages slowly. The last amendment act was 92nd of 2003, which brought Santali, Dogri, Mathili, and Bodo. How Schedule 8 benefits? So a person can file to NTA or any other authority conducting any exam for all India competitive basis that please use my language, otherwise you are violating my right. Then RBI have to include it in their currency note denominations in order to people basically understand what the value is, right? There are still many people who doesn't know what 100 or 100 means. 100 in English and 100 in Hindi. So the localization of the denominations due to the Schedule 8 helps in running of our economy. And then various assembly parliamentary debates. Then there is your court where you can file a particular PIL in your native languages if recognized under Schedule 8, right? Then we have 9th schedule of the Constitution. Again, why it is in the news? Simply we know there are a number of cases being challenged today in court saying that they are unconstitutional. Why? Because the provisions of it undermines the basic structure which you have read in last session, as well as they have provisions which basically violates the fundamental rights of a person ABC. So a person ABC wants to give an exam in Tamil Nadu or Maharashtra, but he is facing this particular hindrance of reservation. Remember, not language. A state can ask, Bhaiya, you need to know this particular language in order to work in our state. In Gujarat, you need to know Gujarati. In Maharashtra, you need to have Marathi. In Tamil Nadu, you need to have a knowledge of Tamil. So they are in their capacity, right capacity, to have a paper completely dedicated on the particular aforementioned language. However, if there is particular reservation which says only Tamil native speaking people can give this particular exam, such laws are violative of your fundamental rights. And recently we had a case of Tamil Nadu and Maharashtra both being questioned by Supreme Court whether they are valid or not. 9th schedule came in highlight due to that. If we to take an overview of 9th schedule, it is sort of a briefcase where governments can pass a law. Governments means center and state both. Center can make a law and then basically president can put हाँ भैया 9th schedule बनेगा. While you have another which is your state law. So a state can pass it, then pass it to governor, and governor can recommend it to home ministry and the president, and then by the procedure, the state law can also be put in the 9th schedule, right? And once they entered in 9th schedule, they are not in violation of fundamental rights. They are sort of in constitution, but they are outside the scope of constitution. IR Colo challenged this particular law, which was placed under ninth schedule, and at that time the Supreme Court said that every law under ninth schedule which was made before April 24, 1973 is going to be legal. It's going to be constitutional and not challenged right now. It can be challenged afterwards. Remember, it does not mean that Supreme Court, after saying that भैया इस particular date के पहले जितने भी laws है या this particular any law which is passed before the aforementioned date are completely legal or sacrosanct. No, Supreme Court has said for that particular time period only, right? You can challenge, and they are being challenged right now. Cool. Why the date April 24, 1973 is important? Can anyone tell in the chat? Correct. So this was the date, day when Keshwanand Bharti case verdict came, and an auspicious date for many. You need to remember why the case is important, not only because it was a milestone in our constitutional development, but there is one another reason why it may be important for this particular prelims. Any idea? Okay, you may not have any, or even if you have, let me tell you. So Keshwanand Bharti, the saint, the Shankaracharya who had this particular whole case filed, he unfortunately died a year back, right? So despite being a year-old news, it is still very relevant to present times and becomes increasingly important because a personality related to a case has died, a case which was monumental for a constitution, right? So try to cover the Keshwanand Bharti case in brief. Again, remember, in polity, try to have a 20-80 part. 20% of anything you need to remember, or more accurately, in polity, 20% of polity you need to remember. It is the other 80% that you only have to see. If you forget, no issues. But that 20%, you need to hold it very tight. If your luck be, the prelims may have every question from that 20%. And even if your luck is bad and nothing comes from that 20% directly, there would be some essence of those 20% that may be asked indirectly, right? So have a certain amount or certain section of polity equivalent to 20% of the whole syllabus that UPSC mentions, right? Okay. Next, we have right to silence. Again, we know in Article 20, Clause 3, any person is free. Basically, he cannot say that I committed a murder, right? He cannot be or she cannot be a witness against himself or herself. Now, this protection was given in perspective of criminal proceedings, but afterwards we have certain instruments that have been developed, such as fingerprint, voice print, eye print, right? Blood test. So from a perspective, these are all what? Person himself. My fingerprints are me. My blood is me. My eye print is me, right? So is it violative when government says that you can use tools employing such techniques without any problem? It came out that no, there is no violation of right to silence which is emanating from Article 20, Clause 3. This is why this particular article was sort of in news. Okay. Next, we have reservation for locals in private sector. Again, is there any constitutional provision which says that state government can provide for reservation for locals? No. Is there any provision that state can provide for any sort of reservation when it comes to public sector jobs? Yes. It cannot be only on the basis of place of origin. So few states, what they used to have, that if you are not from, let's say, MP, or you are not from, say, Punjab, you cannot apply for this particular exam. Or if you are only from Punjab, Haryana and Delhi, where the Punjabi language was affluently used, you can apply for my Punjab PSC. Such things are violative of fundamental rights. There cannot be any discrimination solely based on one single characteristic. But a combination can work. A combination can work, right? When it comes to private sector jobs, there is no such law. There is no such provision. It is completely violative. But the question now arises that if there exists such thing in state or a public sector job, why not in private sector jobs? Which becomes a question for you when it comes to mains. For prelims, you just need to remember there is provision for public sector jobs, not for private sector jobs, right? And when it comes to 75% reservation, it also has been done. Tamil Nadu has around, I think, more than 70 or percent reservation in their public sector jobs, right? Then we have affirmative action. See, affirmative actions was introduced in US, right? And basically it means that you can do certain steps, you can take certain series of actions which is sort of discriminatory, but it is done in order to reduce the prejudice against individuals. If I have to equate affirmative actions with anything, it is simply equity, right? There are a number of philosophers who believe that equality is a dream, but equity is a reality. And we see equity used number of times. Reservation again is a form of equity, right? Affirmative action again is a equity where you are discriminating in a positive manner in order to counter historical patterns of prejudice or violence against certain identities. We have reservation which is parallel to this particular term, right? Next, we have Ranganath Mishra Commission. It was officially known as National Commission for Religious and Linguistic Minorities. Why only religious and linguistic minorities? There is a particular article in Constitution which says there are only two, which are your religious and linguistic minorities. Please tell in the chat which article is that. Correct. There are two articles, 29 and 30. Agreed. Which one of it has minorities, religious and linguistic used in its definition? Thus, Article 29 says about chalo badhiya. So in Article 30 it is said that minorities have right to establish their institutions, and these minorities can be based on religion or language. So a distinction on religion and language has been made under Article 30, quote unquote. Okay, so this was a 2007 report which basically said about the status. Again, not much to remember. it was again in news because we have current going of subclassification of OBC. Other backward classes, recently we have G. Rohini Commission, which is doing the subclassification. Similarly, recently also Supreme Court said that reservation needs to be looked upon again. And in that it said that subclassification of other caste and community need to be done. This was also covered by a request by certain minorities that scheduled caste status currently is being given to only either Hindu, Buddhist, or Sikhist. That is, any other minority are either minority, right, or they are not provided the scheduled caste status. This is why the Rangnath Mishra Commission was in news for a few moments. Need not to remember much. What need to be remembered, we have discussed, right? We know the article why, due to why this commission was for religious and linguistic minorities. We know there are two commissions. Sorry, there is one commission working on subclassification of OBC, which is your G. Rohini Commission, retired Justice G. Rohini Commission, and the second about the reservation issue again, which Supreme Court said something something. Jab tak there is no any concrete action, do not dive into the sea of information just because it was mentioned in newspapers. Okay? Then you have Article 355, which is basically that any state which is facing any external aggression or internal disturbance, Government of India has to intercept and provide for public order in the particular state. Why it came? So Article 355 has been provoked by number of people belonging to Party A and Party B and Party C related to West Bengal. So they have again asked that emergency provisions need to be called upon in the state of Bengal because they feel that there is some internal disturbance as well as external aggression which is being carried on and the state is not able to combat with it. Right? Then we have right to work. See, right to work. Before right to work, we had a particular phase where disability was a big issue, right? In order to combat the injustice that is being faced by your disabled community, which is now called Divyang, which is the ministry responsible for them? Type in the comment section. Which is the ministry responsible in for addressing the problems of your Divyang or disabled community? Is the ministry called Divyang Ministry only? Correct. Very good. I was not expecting, but I am very happy to see आप लोगों को पता है. It is Ministry of Social Justice and Empowerment, which is mandated to address the problems of your disabled or Divyang Jan, right? So in this regard, we also have this particular thing which is not related to it. So Punjab became the first state to implement the right to walk, which basically mean that the pavements we have, the footpaths we have made, they have to be in a fashion such that people can walk. And if you go in municipal court, it is, I think, also called your I am not able to remember the correct acronym, but I think it is called RBS. So if you are going in such detailed things, and I hope you all get to have a taste of that particular book when you become officers. In that, it is written that footpaths and the walking pavement, they are made for two purposes: walking and cycling, right? Every municipality has their own code, but generally they have agreed that they are used for walking and cycling. So after state has passed this particular act, it has become the right of citizen that they can report that a government agency is obstructing that particular pavement or the particular path, right? And it is breaching my right. Okay. So what does it entail? Basically, every road now has to have a footpath. There can be no road made without any footpath within the core center, within the core or the center face of your city. Second, it also need to accommodate that there are cycles. Either make the footpath such that the cycles are comfortably, crawled upon it or run upon it, or make a separate cycle track which is accessible to all. Right? This is what right to work entails. Lesser chance Prelims is going to ask this. It is more a state PSC question, but I think having a brief idea about why right to work is important may help you in means in some capacity. So this was all. Handing over to you, ma'am.
Thanks a lot for the session. It was really a detailed session. Please have water. And yeah, so since we are done with the part 2 and part 3, okay, and might be tomorrow, like, no, if there would be session, we'll definitely inform you for the next session. All right, for the next 10 minutes, since you have read so much in the session, so for the next 10 minutes, let us have a quick revision.